Yes, Mr. Mould.
My Lord, may I just deal with, as far as I'm able to, with the question of the regulatory control. If you, Lords, my Lady and my Lords, would turn to MS page 288, which is in the Upper Tribunal's decision, and it's paragraph 49. We very conveniently set out.
Sorry, MS
288.
Right.
The Upper Tribunal decision, internal paragraph 49, the Tribunal very helpfully is setting out the evidence of Mr. Coates of Sainsbury's. And you'll see that in that paragraph, Mr. Coates' evidence is summarised. For regulatory reasons, it was necessary that that is to say, Sainsbury's Bank, be a separate entity, and that its assets and liabilities be kept separate from other subsidiaries so that the group as a whole did not have to comply with the onerous supervisory and regulatory regimes applicable to banks. In 2010, the only ATMs operated by the bank were in Sainsbury's retail premises. That's the best I can do in shedding a little more light on it within the material that's before the court. If the court would like something more detailed.
Well, I mean, if everyone's happy as that is an accurate summary for all the relevant.
It certainly is an accurate summary of the evidence that was given by all parties.
Or a sufficient summary, anyway.
And you can see that from paragraph 53 on the next page. Because as the Tribunal says, we've only added to the detail of the Sainsbury's evidence where it was necessary to do so to deal with some specific point.
Yeah, thank you.
Yeah. Yes, I think the corporate structures may not be the same in every case, but the rationale for having the group, having the bank separate from the store operator is going to be the same.
Indeed so. Yes. Thank you.
I noticed, for example, in the case of Tesco, that the bank's registered office is the same as the registered office of RBS. So it presumably isn't part of the Tesco group of companies in quite the same way as the Sainsbury's bank is.
I confess I can't answer that question, but your Lordship may well be right. If there is something I ought to tell you about that, I will make sure that we tell you. Yeah. In that case, I am going to, if I may, spend, I hope, no more than 10 minutes just outlining the submissions that we make in paragraphs 82 to 102 of the Tesco case, MS 186 to 192, paragraphs 82 to 102, MS 186 to 192 on movable ATMs. This relates, on our facts, only to the putative site for an ATM on the first floor of the Nottingham store. The photograph is at MS 404. You were shown it yesterday. The relevant paragraphs of the Upper Tribunal's decision are paragraphs 134 to 135 at MS 308, and the relevant paragraphs of with a conclusion at with a conclusion at 143 at MS 310. So reasoning 134, 135, MS 308, conclusion 143 at 310. That rationale and conclusion upheld as lawful by the Court of Appeal at paragraphs 55 to 57, MS 264 to 265. Paragraphs 55 to 57, MS 264 to 265. The issue is whether it is a correct application of the geographical principle which was stated in the Woolway decision to carve out an area of floor space which is otherwise not to be distinguished from the larger territorial block within which it is comprised by reference only to the fact that a machine has been placed upon it. And with having stated the issue, may I take you firstly to Woolway and to paragraph 49, which is at MS 1379. And if my Lord Carnwath will forgive me, I'm only going to refer to one paragraph or two paragraphs in the speech of Lord Newburger. MS 1379, paragraph 48 and 49, where Lord Newburger, who of course agreed with the leading judgment of Lord Sumption, and indeed the judgment of Lord Gill, said this: at first sight, it might appear that whether certain premises constitute one hereditament or two hereditaments should not depend on how those premises are occupied. And he went on to explain why that might appear at first sight to be true. Then he went on at 49. Nonetheless, on further reflection, it can be seen that the occupation of premises can in some circumstances serve to control their status as one or more hereditaments. He referred to the example of the office building, which was let out to multiple parties. And then over the page, at 1380, the relevant passage, furthermore, it is well established that premises are not merely liable to have their rateable value assessed, but also to have their status as a hereditament assessed, by reference to the machinery, plant, and other structures which have been placed in or on them, whether by the occupier or by somebody else, sometimes even if the structure retains its character as a chattel. And he referred to the principle stated by Lord Radcliffe in the Wilkins case that you were shown yesterday. And I wonder if we might then turn briefly back to that at 378 in Wilkins.
In that particular, it's funny to see, I'd forgotten that I didn't agree, or at least I hadn't specifically agreed with Lord Newburger. I suspect it was partly because of the generality of that sort of statement, and I was a little cautious about it. But
yes, I mean, I don't think I hope I'm not being impertinent to Lord Newburger by saying that it was really a pointer to a principle that one finds.
Anyway, he had two people agreeing with him, so he's probably good enough.
Yes, I mean, I think your lordship was at page 1383. You expressed some reservation about contiguous floors in single occupation, which is a rather different question.
I think I was anxious to tie it to the particular case.
Yeah. In any way, may I ask you just to turn back to Wilkins, which you'll find at tab 14, MS 1154, and the particular passage where the statement of principle is set out is at 378 or MS 1170. Mr. Morse had showed you this, so I'm not going to eat up time unnecessarily on it. But as you recall, in Wilkins, the argument put by the ratepayer was that you can't be rateable but in reference to a chattel. And Lord Radcliffe said that's wrong. The first break at 1378, he deals with why it's wrong in two contexts. One is it's wrong for the purposes of assessing a rateable value, and the second is that it's wrong in relation to the determining whether there's a rateable occupation or not, so whether there's a hereditament, effectively. And he goes on at the second break to set out the principle. On the second point...
I'm sorry, what's the page number again, please?
MS 1170.
Thank you very much.
Yeah. At the second break, at the middle of the page, he says, on the second point, I think it's equally well established that a structure placed upon another person's land can, with it, form a rateable hereditament, even though the structure remains in law a chattel, and as such the property of the person who placed it there. And then over at page at 380, the other passage I invite you just to look at, about 7 lines in, when the owners of pipes, cables, posts, etc. are rated as occupiers, they're rated in respect of those things themselves by means of which they occupy land, not merely in respect of the land that is occupied. C. Corey and Bristow, it was the moorings which were treated as rateable. And then the third reference, just at the break, in my opinion, the present case really centres around the question whether the sheds erected on a building site by building contractors for the purposes of his operations involve such a degree of permanency in his occupation as to make it a rateable one. So what one gets from that is this in my submission. The principle stated in Wilkins is that movable property, when enjoyed with land for a sufficient period of time, is capable of forming a rateable hereditament with that land. In other words, the hereditament is defined by the chattel with the land, not by the land alone. And that is the prior question that needs to be asked and answered before any question of whether the occupation that is thereby created is one that fulfills the ingredient of permanency that, as we saw earlier, is the fourth of the four ingredients of rateable occupation. What Mr. Morshead does is he jumps straight to the second question. He does not ask the question, is there here a hereditament formed by a chattel enjoyed with land and defined, and thus defined, which if it exists, has been occupied for a requisite degree of permanency. And the technical point, but the important point is that it is not, of course, suggested that here there is a hereditament comprised of an ATM, a chattel enjoyed with land. The description of the hereditament in this case is a site, is an area of land for an ATM. And so one cannot apply the Wilkins principle, that is the submission, because that is not the way in which this hereditament is defined. It is defined as a site. And so one has to look for some other means of defining it in accordance with the geographical test. That's our submission.
Is that a rather fine distinction?
Well, it may be fine, but it is one that, in my submission, emerges clearly from the way in which Lord Radcliffe has expressed the point. Or to use Scots lawyers' language, it is not said here that we have a hereditament. We have a hereditament that is formed of property that is heritable by accession. As my Lord Reed will know, that is the Scottish way of encapsulating the principle set out in the Wilkins case. So one has to, the target, if one is going to apply the Wilkins principle, is necessarily not simply the site, but is the chattel and the site together. That's how you define it.
But isn't that in substance what is said by Mr.
No.
Morshead?
He in my submission, not. And the difficulty is that if it's right that there is a prior logical step and that one has to be able to identify the hereditament itself before any question of its occupation arises, then one has to be able to apply the principle in the way that it is expressed. Otherwise, one is failing to follow principle, and one is allowing the mere use of a site for the purposes of stationing a machine to be the self-defining characteristic of the exercise, which is the thing that Lord McGee said in Clydesdale is impermissible. It may be, I very much take your logic point. It's a fine distinction, but I say it's an important one because rating depends upon being able independently of occupation, save in the narrow circumstances of the Wilkins case, being able to identify a separate unit of property as distinct from the larger territorial block, and to do so in accordance with an applicable principle. And my simple point is the principle that Mr. Morshead seeks to deploy here, which is Wilkins, doesn't work, because that's not the kind of arrangement that Wilkins is contemplating. That's why in Clydesdale, I don't need to take you to it because you've seen it, that's why in Clydesdale, Lord Gill said, we don't have hereditament that comes into being through the principle of heritable by accession. We don't have a Wilkins case. we therefore have to look for some other principle. And he says one other principle, see the Austin Reed case, is where the agreement defines the separate unit, the units, which can then be identified on the geographical test. But he said in the agreements in that case, they don't do that either. And of course they don't in this case, as we've seen. So if you can't do it by reference to Wilkins, and you can't do it by reference to the agreement, then how do you do it? And we say the answer is there isn't another principle that fulfills that purpose. Now, I've gone through that pretty briskly, but you'll see it set out in more detail in our printed case. But that is, and the references to Clydesdale and Austin Reed are there given. But that's essentially the point that we're saying. And the reason why it matters, I mean, obviously, if the court accepts the position as set out in Mr. Javel and my submissions this morning, then the battle line is simply drawn up a little further down the line. One has a hereditament, but one looks at the issue of paramountcy. But obviously, there are many examples in the list. You saw the Coinstar site at Walsall yesterday, which is an example, as I've said today, where machines have been, the presence of a machine on an otherwise undistinguishable area of floor space in a store has been used as the trigger for identifying a hereditament. And it's been on the basis of the principle, the way that Mr. Morshead has put it, and I simply question the reasons I've given, whether that is in fact an approach that can be justified in accordance with established rating principle. So you'll forgive me for having gone through it at such pace. I hope at least the point I put is clear, and I can, if that is so, I'm conscious that I need to sit down.
Proceeding at pace is not an occasion for forgiveness.
Well, no, but if it's at the expense of clarity, then it does.
So just remind me, I sort of slightly lost track of all this. The movable ones, these ones you've been talking about, what was decided about them below?
That they were not, this was the only one.
Yes.
That this was not capable. That the fact that the site.
I mean, the Court of Appeal decided that none of them were.
No, what happened?
Rateable.
Sorry, I should have. In the upper tribunal,
Yeah.
they decided that the only one of the candidate sites for ATMs that they were asked to consider, which was not even capable of being defined as a separate hereditament, was this the site of the machine on the first floor of Nottingham. Otherwise, they said that the physical indicia, such as holes in the wall, etc., were sufficient to enable a hereditament to be capable of being defined, and then one went on to the question of paramountcy. In the Court of Appeal, the court essentially upheld that rationale, and that is what you'll find that in the paragraphs I've mentioned, paragraphs 55 to 57 in Lord Justice Lindblom's judgment.
But if you're right on this, and the Court of Appeal are right on all other points, you still get home.
Exactly. This is, in a sense, this is a bonus point for me, because if I lose on this, I say I still win on Southern Railway. But clearly, it's of interest for the reasons I've just given to Tesco's.
But you also say, do you say that none of them are capable of being?
No, I'm not taking that. I'm not quarrelling with that. Mr. Kalinsky is so that's the next stage in the argument, effectively. Yeah, we've gone. As Mr. Javel said, we've sort of gone back to front in a way.
Sure, there's been great discussion in landmark chambers as to how all this is going to be divvied up. So.
Well,
anyway, I think I've got the picture.
Have you? Yeah. Okay. Well, as I say, one always says this, but I really mean it this time. If you do need my help any further on this point, I'm happy to give it. But I'm conscious I need to sit down if otherwise. And,
Can I ask you to clarify one matter for me?
Yeah.
We saw in the passage that we were looking at in the judgment of Lord Justice Tucker
yes.
in John Lane, and it's the judgment of Mr. Justice Jenkins is rather similar. references to exclusive occupation.
Yes.
The other authorities speak of paramount occupation, and it rather looks to me as though in Lane, the reference to exclusive occupation were under reference to the facts of that case, where the contractors on the building site had exclusive occupation of the huts that their workmen were using. But have I got that wrong? I mean, in other words, is Lord Justice Tucker to be read as qualifying in any way the paramount occupancy test?
No, the answer to that question is no. He certainly saw himself as applying the paramount occupancy test because, as we saw earlier, he identified at some length the principles set out in Southern Railway and in Holkin. My reason for referring you to the top of page 356 was really that I thought you might want to look at that. As a means of resolving the question of a straightforward way of approaching the application of those principles.
Yes.
But there is, I mean, plainly, one way of expressing it is to say that the second of the ingredients of rateable occupation set out in Lang, exclusive occupation for the particular purposes of the possessor, the way in which, in a case where there are two candidates for rateable occupier, the way in which you resolve that question is by resort to the paramountcy analysis.
This is subject to paramountcy.
Yes.
And he's been citing immediately before that. He's been citing Lord Wright in Southern Railway, who was distinguishing who discussed the position of a lease where the tenant would have sole and exclusive occupation, notwithstanding that there might be restrictions imposed in the context of a lease of premises within the curtilage of a railway station.
Yes.
By the closing of gates and so on during the night.
Yes. That's the wrong sort of exclusion, Mr. Morshead would say. Yeah.
But the passage on page 1147, 356 of the report, doesn't need the same qualification. Have I understood your submission correctly?
I'm so sorry.
The passage on page 1147, at the top, which you took us to a moment ago, before the adjournment, and you described this as being a two-step analysis.
Yes.
This isn't subject to the same qualification about paramountcy that you've just.
No, it's a means. It's a means of. It's Lord Justice Tucker's, if you like, practical means of applying the paramountcy principle.
Yeah.
That's the point. And that's why I thought you might find it helpful, because I think that was a point of some concern as to how you give guidance, if you like, to the rating
Thank you.
world. Yeah. So.
Yes, thank you very much.
I'm grateful. Thank
Mr. Road. Mr. Williams, do you follow? Oh. And I take it Mr. Lewsley does not wish to. Very well. Mr. Kalinsky.
May it please my lords and my lady, on behalf of Cardtronics, first of all, may I adopt the legal submissions made by Mr. Drabble and Mr. Mould. I will need to explain when I come to rateable occupancy, albeit briefly, how those apply in the particular circumstances of the Cardtronics case, which is somewhat different. As my lords and lady will appreciate, the characteristic of the case with which I'm concerned is a small convenience store. You recall the photographs. It's an external facing keyboard. The ATM sits within the shop, and you'll recall at 423, you don't need to turn it up, the servicing arrangements, if you like, on the agreed facts, effectively blocking the aisle for the purpose of conducting those arrangements. So those are the physical characteristics which give rise to the the point that I take further than the other ratepayers, which is whether there is anything here on a proper legal analysis that is capable of being a unit of property. And there are points of approach that are, although they are entirely consistent with the submissions that my learned friend Mr. Mould has just made to you about Wilkin, I take that point further than he does. So the bulk of my time I'm going to spend on that. But before I do that, may I start with just one reference on general approach to carving out that the court hasn't yet seen. Then I'm going to deal with my, if you like, bespoke point in relation to the approach to whether there's a unit of property on the facts of my case, and then I'll deal with rateable occupation. So the one authority that I want to show you is the Lands Tribunal decision in Burns-Stewart. This is on under the heading General Approach in a Carving Out Case. May I just remind the court why it might be interested in this case by reference to Woolway, because you'll recall Woolway's at Authorities tab 23, and you'll recall, I did this very, very briefly just to set the context, but you'll recall that paragraph 6, MS 1365, Lord Sumption in paragraph 6 sets up the two possible tests of geographical and functional, and then he reviews a number of Scottish cases, and one of those cases that features heavily in his analysis, if we go to paragraph 11 of his judgment on MS 1368, is the Lands Tribunal, Scottish Lands Tribunal in the Burns-Stewart Distillers case. And that informs the key principles that he articulates at paragraph 12. And you may have noticed when we went to Lord Newburger, which was shown to you for other reasons, he similarly drew on Burns-Stewart. It's fair to say Burns-Stewart is a decision that influenced the adoption of the geographical test as the primary test in the particular circumstances of the Woolway case, which, as my Lord Carnworth noted, aren't necessarily the approach to be adopted in a carving out case. So that's why it's perhaps useful just to sense check what Burns-Stewart says about carving out. So that's why I go there. And if we go to tab 9 of the authorities, which is MS 1048, if for the start of the case, but if we could go straight to MS 1072, the facts of Burns-Stewart are there's premises on opposite sides of a road. One set of premises is a whisky bottling and distribution site, and on the other side of the road is a warehousing and offices. And the essential decision is, well, although this is one business, these are two geographical units. The Lands Tribunal for Scotland in this case was led by Lord Magee, who's obviously the same Lord Magee who gave the judgment in the Clydesdale case. I want to just pick it up a third of the way down, MS 1072. So for the assessor, reference was made to the Fife Assessor and National Coal Board case. This was a case which supported the proposition that the geographical test was not to be the sole determinant. There was scope for reference to function. And then we get the observations of the tribunal. If I drop down to the next paragraph, the case, as we have observed, was concerned with the question of whether reference to function could justify carving out a part of what would otherwise have been treated as an unum quid. Nothing in that case deals positively with the use of function in the opposite direction. Now, obviously, Woolway's a case about you can't use function terribly persuasively except in exceptional circumstances in the other direction. In other words, in uniting two single units. But it's
in the Burns-Stewart case, weren't the two units linked by a tunnel under the road?
There certainly was a form of linkage, but it was held to be insufficient in the circumstances of the case. if I may just go over the page, at the very top of 1073, the Scottish Lands Tribunal says this: dicta in the carving out context cannot simply be assumed to apply to the case where physical separation is clear. If a primary feature of the geographical test is physical separation, it may be easily accepted that interposition of a physical feature such as a building, a river, road, railway by itself creates sufficient separation. And then this is the bit that I emphasise. This is a quite different situation from one where there is an apparent physical unity, which on examination appears to require some form of further division. Units within a building may or may not be seen as separate units of occupation. Where physical divisions are uncertain, it may well be relevant to have regard to elements such as use or intention to support the view that a relevant division does indeed exist. Now, I would add, or does not exist. And may I just try to cast some light on the reference to intention, because obviously, as a shorthand, that observation may be loaded with the target for a criticism, or we're not concerned with motive. But my suggestion is that what's meant by intention is the intention as manifested in the nature of the rights or occupation arrangements properly understood in their context, taking account of matters such as purposes. So I would suggest that this broad principle, which has informed what's described by Mr. Morshead as the seminal case, one of the seminal cases in rating, and the geographical test, well, on the face of it, it's a different range of considerations that apply in the carving out. And I would respectfully suggest that general principle is consistent with the examination in Halkin of understanding the nature of the contract. It's consistent with the distinction that was drawn in the Austin Reed case that Mr. Mould referred to a few moments ago, which probably haven't got time to go to, but is tab 27. But the critical distinction there, and it's referred to in Clydesdale, was between a specific carving out as a matter in the lease for a site, which was held to be a separate heritable subject, and the generality of provisions for advertising which were not specific. That's a distinction that arises on an analysis of those arrangements. And there's also, again, perhaps I could just give you this for reference, there's a very helpful, I would respectfully suggest, discussion in an English Lands Tribunal case of Esso that I will refer to later in the analysis as well, where it's made absolutely clear that one shouldn't misread the part of Southern Railway that says the form of the agreement is of little importance. Don't misread that to suggest that analysing the nature of the arrangements between the parties is of little importance. That's of fundamental importance to the exercise that needs to be conducted. So my holistic submission is that the right approach is to look at the physical matters, the use, the rights and the function as part of an orthodox inquiry as to whether or not there is a carving out. And
I mean, sorry, you keep on talking about carving out. We've seen it used, and we see it here in inverted commas.
yes,
I mean, has it acquired a formal status or somehow as a term of art? Or
well, probably not. It has been referred to for about.
Well, I mean, where do one go back? Where does it start from? The carving out.
I pass as a direct answer. I think it's been round as an expression for over 100 years, I think. But may I just encapsulate what it reflects, or does my law?
Well, no, I'd just be quite like to be referred to where authoritatively it first
I'll see if
became part of the
I can answer that whilst.
lexicon.
If I can proceed,
Yes,
I'll
absolutely,
come back if I can help on that. The point, though, however, is that my submission is that the approach of Lord McGee in Clydesdale, which is much criticised by Mr. Morshead, but I specifically adopt what Mr. Dravel showed you, which was that actually the substance of the analysis does not fall apart on the use of the word rivals in his analysis. And if one looks at actually what the Scottish Valuation Appeal Committee Tribunal thought the Lands Tribunal had decided, it's very pithily encapsulated. So we're in the replacement documents, the slim bundle at MS 1840. And in paragraph 21, there's a very pithy encapsulation of what the tribunal did. It had a look at the whole of the relevant facts bearing on the nature and use of the subjects, including their characteristic feature as part of a shop or store. The subject should not be treated as separate units and should not enter on the roll. That's start of paragraph 21. And then at the end, the analysis of the tribunal is summarised as balancing the whole of the evidence as to the physical circumstances, the arrangements for use of the machines, and the practical purpose of the occupation of the subjects. The tribunal was satisfied that there was no basis for treating the subjects as separate units of lands and heritages. So that's how it's described by Lord Gill. And then, as I understand the judgment, he is in effect, in paragraph 24, upholding as correct that approach, albeit giving a pithy reason as to why, in his view, there is no unit of occupation to be found on the facts of Clydesdale. So my submission on that point is that the exercise that's criticised that Lord McGee undertook in Clydesdale derives from an orthodox application of an approach in a carving out context that's consistent with the Burn-Stewart case, and that those, if you like, it's consistent with the idea that this is, as I think my Lord Kerr called it, a multifactorial analysis where these elements are all feed into it. So that's the overall context in which I make my submissions about the unit of property in the facts of my case. May I then go on to the factors that are particularly germane to the proposition that I say there's no unit of property here capable of being shown in the rating list. So I start with the proposition that it's common ground that the ATM itself is non-rateable plant. The site is the floor space. So one feature to note is that nobody is suggesting that there is any way of defining the site other than by reference to the location of the ATM itself. But the issue which arises on my case is whether one can take account of the ATM in defining the hereditament. Now, the upper tribunal held that you could, but even if you did, ours was a borderline case, and that was upheld in the Court of Appeal as an acceptable judgment, but again, taking account of the ATM in the definition of the hereditament. Both the Court of Appeal and the upper tribunal proceeded on the basis that this point, i.e., can you take account of the non-rateable plant in delineating the hereditament, was free of authority. Now, my learned friend for the Valuation Officer, Mr. Moorshead's case, his written argument is prefaced on the fact that the answer is to be found in Wilkins, the chattel cases, and in his oral submissions he relied on Wilkins and Southern Railway for the proposition that the chattel can be taken into account in defining the hereditament. I say, on a proper analysis, these cases do not support the identification of the hereditament by reference to non-rateable plant. The critical difference, and I adopt what Mr. Mould has submitted to you, but I'll show you some additional references to make that good. But the critical difference is that in Southern Railway, the showcases themselves were the hereditament which was occupied. In Wilkins, the hereditament was the builder's hut together with the land that was occupied. In our case, it is merely the floor space. So it is a different case. Now, my learned friend has shown you what Lord Neuberger said in paragraph 49 of Wallway. He was drawing direct, it wasn't the subject of argument in that case, as my Lord Carnworth may recall. Rateability of plant wasn't an issue in that case. And my submission is that one can't read Lord Neuberger in paragraph 49 of Wallway as making any positive finding about what approach one adopts with non-rateable plant. The authority that he derives that general proposition from Wilkins, and when we go to Wilkins, I submit you find that the reasoning clearly doesn't apply to a scenario where we are dealing with, where one would be dealing with non-rateable plant. And I'll show you why I say that by reference to Wilkins without repeating what Mr. Mould has already shown you. So Wilkins is at tab 14. And may I go first of all, appreciate this is the third time the court has been shown this authority, so I will just go to the passages that haven't already been covered that may help on this. So the first point I'd ask the court to note is at 1162. Before this matter got to the House of Lords, it was in the Lands Tribunal, and the Lands Tribunal rejected the contention put forward by the ratepayers that the various buildings were plant in the sense that would be covered by the Rating and Plant Act. So that's from 1162, a third of the way down. So that there was an argument earlier on in proceedings that the builder's hut would be caught by the express self-contained statutory code, as my Lord Carnworth put it, of determining whether it's rateable or non-rateable plant. Lands Tribunal rejected that. That point is not pursued. So the whole premise of the argument is that there's no statutory preclusion from, to put it neutrally, taking account of it in value. But that's the basis on which the point emerges. And then one does, I respectfully suggest, have to go to both Lord Ratcliffe and Lord Tucker briefly. So Mr. Mould has shown you some of this already.
Sorry, before we look at this, can I just be clear? When we talk about non-rateable plant, it's ages since I've looked at this, but in terms of the legislation, are we not? Is that not in terms of whether plant is taken into account in determining the rateable value of a hereditament?
My Lord, that's an entirely relevant observation, and it's relevant to the passage I'm about to show you. So,
but you're talking about it in a rather different context.
I am using a imprecise but much used shorthand of non-rateable plant. My Lord is quite right that in the particular legislation, the specific direction is it shall have no effect on value. And I accept that, but I need to show you what the House of Lords has said about that in Kennet. But also, it is worth noting that in Iceland, there's a careful analysis of these provisions. Yeah. And this court uses as a shorthand non-rateable plant, because that's how the argument proceeded. But what this case throws into sharp focus is, if you like, whether that shorthand is accurate and what, if any, role a creature that hasn't been seen, certainly by this court before, of a putative hereditament only to house an item of plant whose value is to be excluded, is to be treated. Yeah. Is it? And what role that plays. So, my Lord, it's
yes, well, that's been, and thank you for raising that, because that's been sort of worrying me all through, and I certainly wasn't addressing that in Iceland because it didn't arise.
No.
But it's quite important to understanding how this case is analysed.
Yeah. I mean, obviously, it's one thing to say that the plant should be disregarded in determining the rateable value of a hereditament. It's something else to say that you disregard the plant for the purpose of determining whether there is hereditament in the first place. Well,
I agree. It's an issue that is not answered on the face of the regulations. But my submission is, because the courts have never encountered the artificial analysis of the creation of a hereditament solely to house an item of non-rateable plant, certainly not at this level. There have only been 3 cases Well, there's Stringer, where the submission was made that it was artificial. There's Clydesdale, where it was held there was no hereditament. There is Bank of Ireland, where on functional basis it was held to exist. So that's argued against. And there's a case called Selector, which is in the bundle and which is referenced in relation to vending machines at railway stations, where they look very, very carefully. But in Clydesdale and Selector, they very consciously exclude from consideration the machine itself in asking the question, is there a hereditament here? Now, this is the first case to raise that point head on. I've raised it. The answer that's offered to this court from my learned friend, Mr. Moorshead, is that it's consistent with Wilkins. I say it's not, because Wilkins is a case where the hereditament is the chattel together with the land. That's, I say, very different. So my answer is effectively Wilkins doesn't help, and I say it positively harms basically for two reasons. One is that the plant point, the statutory code point, was raised below, and this was expressly not a plant case. And secondly, because I say when you actually look at the way the courts express themselves, and there's a couple of passages I want to show you that I can rely on that to say you shouldn't take account of the ATM. But the other point I need to show is I also say that Lord Keith in Kennet assists on this, and I will show you that next. So that's.
Are you? I mean, are you coming to Selector at some point, or?
I was going to refer to it, but
No, you say it's analysed there.
Yeah.
This particular problem, and I'd certainly be interested at some point to be referred to it, even if not
yes,
part of your submission.
I think that might be slightly overstating. It doesn't take on this point, but what it does do is it looks at vending machines by reference to the site rather than the machine in thinking about whether there's a hereditament.
Okay. Right,
I'll take my lord, or refer my lord to the key passages of that. But if I may, can I stay on the House of Lords in Wilkins and Kennet, because those are the if you like, the principal cases that may or may not assist them in this point. And I say they do assist. So you'll recall that Mr. Mould has showed you at MS 1170, the idea that the structure can, placed on another person's land, can with it form part of a rateable hereditament. And he made the point it's the builder's hut together with the land in that scenario. That's materially different from our situation. May I then just deal with the reference then to Southern Railway at 370, MS 1171. So they refer to the fact that in Southern Railway was a natural application of the potential rating of chattels. The whole issue was whether certain buildings or structures situated within the confines had been so let out as to be capable of separate assessment. Certain of the structures, such as the kiosks, small shops and showcases rested on the ground by their own weight, would not have satisfied the usual requirements for fixtures, so to be attached, etc. And then there's this aside. Of course, if being chattels, they could not for that reason alone be the subject of assessment, there was an end of the matter. And he says, it wasn't the end of the matter. Now, my submission is if you plug in that insight into what I say you should take from the status of non-rateable plant, you get a clear answer on this logic that you shouldn't be taking account of the non-rateable plant in defining the hereditament. Now, I appreciate that's somewhat opaque from Lord Ratcliffe read in isolation, but I say you can get that also from Lord Tucker, and you can get it from Kennet in the House of Lords. But that's that particular passage that I rely on. That's in our written case, and you'll recall my learned friend Mr. Moorshead said he didn't understand the point. Well, hopefully the point as to what I take from that is apparent. At 1172, I just call attention to the fact again, and Mr. Mould took you to this, but that when they're talking about the approach to cables and the approach in Corey and Bistow, they're making it clear that that's relating to things which are themselves the means by which they occupy the land, not merely in respect of the land that's occupied. So again, the chattel is part of the definition of the hereditament in the Paradigm Wilkins case, and that is different from I say, the position in relation to non-rateable plants. The next reference is if we go to Lord Tucker, 11. His speech starts at 1174, but the bit I want to go to is 1176. And again, I think Mr. Morshead showed you this passage, but I just invite attention to this passage on which I do found my submissions. He says, in my view, on the undisputed facts, it's impossible to...
Sorry, where are you?
I'm so sorry. About 2/3 of the way down.
I've got it, thank you.
In my view, on the undisputed facts, it is impossible to hold as a matter of law that there was no evidence to warrant the finding that there was, in this case, a sufficient carving out or appropriation and sufficient degree of permanence to give rise to rateability, unless the appellants can make good their submission that these huts, by virtue of their construction and liability to removal, were to be regarded as mere chattels. And then he says this, which cannot be the subject of rating or even taken into account as enhancing the value of the occupation of an otherwise rateable piece of land. So there, I say it's of a piece with the idea that if something is excluded from consideration of value, then you are not taking account of it in defining a hereditament. So I say that's consistent, if you like, that qualification of why chattels can be rated is in play in the particular circumstances of our case. And I link this to my written case where we say it's common ground that the ATM in the instant case cannot be the subject of rating or taken into account as enhancing the values of the floor space on which they stand. Now, that's, in a sense, it's common ground, they're non-rateable plants, and that's the proposition that I say follows from the fact that they are non-rateable plants. And I say we are therefore in the qualifications expressed in Wilkins. So that's Wilkins. Can I then go to Kennett, which is at tab 13, MS 1149. It's a short decision of the House of Lords, and the issue was the liability of the occupier of a telephone exchange when they were installing their non-rateable telephone equipment. And the facts are apparent on MS 1150, and can I pick it up on MS 1151, just before the last paragraph? We go into, just to introduce the paragraph on which I rely, a bit further up the page, the respondent's contention in the instant appeal is that during the relevant periods they were not and could not have been enjoying the accommodation afforded by the hereditaments because they had not yet reached the stage when they were capable of use as operational telephone exchanges and were not being so used. So the argument was, whilst we're putting in our telephone equipment, we can't use these as then they're not ready for occupation, and therefore there's no hereditament. And this is how Lord Keith approaches it. In assessing the soundness of the respondent's argument, it is necessary to give close attention to the nature of the hereditament sought to be rated. So pausing there, the identification of the hereditament was absolutely the issue in this case. That hereditament is land with buildings erected on it. It does not include any plant or machinery within that building. And then he refers to the General Rate Act, which is the immediate predecessor of the 2000 plant and machinery regulations. And this is dealing with the point, well, this is relevant to the point that I had in my exchange with my Lord Reed just a few moments ago. So picking it up, the subsection provides, so I'm now on MS 1152, about a third of the way down. The subsection provides that it is for the purpose of valuation.
Hang on a second, can we just see what the subsection says?
Yes.
Well, there again, it's no account shall be taken of the value.
Yes, so
It's the same as here.
so if it's within the specified classes, it's deemed to be present. If it's not, no account shall be taken of the value. So it's the same as what the court considered in Iceland. But this is what Lord Keith does with it, which may or may not assist. I say it is the closest example on point. So the subsection provides that it is for the purpose of valuation that plant and machinery within paragraph B is to be left out of account. And then this is what I rely on. But it must, I think, follow that it is impossible to treat such plant and machinery as part of the hereditament for any rating purpose, even though it be so fixed or attached that it would have fallen to be valued as part of the hereditament under the law prevailing before the statutory ancestor of Section 21 was enacted in the form of Section 24 of the Rating Act. So, in other words, it's my Lord Lord Carnworth's self-contained code point, all the previous law and annexation is out, and Lord Keith says, in the particular circumstances of this case, that if there's a statutory disregard of value, you shouldn't be taking account of that in the rating for any rating purpose, and in a context where the rating purpose he's actually undertaking is defining the hereditament. And his reasoning is nothing can be rated which is not capable of being valued for the purposes of rating, and nothing which is not so capable can be the subject of rateable occupation. So it was rightly conceded by counsel for the respondent that the hereditament in issue here was the land with the bare shell of the building on it, excluding all the equipment therein. So the reason there was a hereditament in that case was because there was a building. In our case, if you're leaving out of account, as I say this suggests you should, the machine, then you simply have an undefined piece of land. You don't obviously have a building. And then just to show what the exercise was, he says the limits of the hereditament liable to be rated having thus been defined, he turns to the question of rateable occupation, and he holds that because they were installing their non-rateable plants, that they were liable for rates. But the point is, therefore, that he treated the process of identifying the hereditament as a prior question to the determination of occupation, and as one where the non-rateable plant should be left out of consideration because effectively he thought it was a necessary corollary of the fact that it would have no impact on value.
So, I mean, in deciding whether there's a hereditament at all, you say we have to ignore the plant and machinery.
Yes.
See what we have left.
Yes, and that's of a piece with what, in fact, the Scottish Lands Tribunal did in Clydesdale and in Selector, which I appreciate.
Was this case referred to by the Court of Appeal?
Yes, yes. Effectively, they said it didn't deal with the question of whether you have whether you take account of the ATM, and they held you should, because effectively it was sensible to do so. Now, my submission is this is a question of legal approach. I submit high authority suggesting you leave it out of account in the determination of the hereditament, and my answer to it's artificial to leave it out of account is, well, it's artificial to identify a hereditament where the sole basis for identifying it is the positioning on there of something which is expressly to be left out of account in the valuation. My Lord Carnworth's observation, this is a peculiar hereditament to value. My Lord Reed's observation, it's a peculiar kind of hereditament that disappears and is incapable of existing in an unoccupied form. Those observations, I submit, are assisted by Lord Keith's analysis in Kennet.
But it's clear authority that you don't just ignore for valuation purposes, you ignore for all rating purposes. And so I must say I hadn't appreciated that.
Well, my submission is that's exactly what my submission is, that this establishes all rating purposes must include the identification of the hereditament. Yeah. That's logical, and it's illogical to identify a hereditament solely to house non-rateable plants. And that's a point that I have argued and pursued in the Valuation Tribunal, other tribunal, and Court of Appeal. My
failed at every stage so far.
So far. But I do maintain the point.
Yep.
So, and I just to draw those threads together, the hereditament, probably said this, but just to be clear why I say this, the hereditament consisting only of the location of non-rateable part, I say does sit very uncomfortably in the statutory scheme. The point it's not capable of existing in an unoccupied state. Now that's in contrast to the builder's hut. So once the builder's hut has been placed on the land, it's there with the land. It can be occupied or unoccupied because it's something that's on the land. So there's something definable that's capable of occupation. Equally, the showcases, when one goes to what Lord Wright said about them, they were occupied by the placing of goods in them. So they are the thing which is occupied. That is fundamentally different to the particular circumstances in the case. Now, my learned friend, Mr. Moorehead, said, don't get too preoccupied by the idea of incapable of existing in an unoccupied state, because traditionally rating has been about occupation. Now, that's fair, but it's an incomplete answer, because actually, since 1925, and this is in our written case at paragraph 19, the statutory mechanism has contemplated a unit of property which is or may become occupied. So it's always had at its heart this idea of an identifiable piece of property which is then occupied. That's, I submit, fundamental to the rating statutory scheme. And I do say, this isn't a valuation case, but I do say that there are some questions that are worth contemplating in terms of how valuation might work, because its value and presence expressly forced to be left out of account. Now, I've dealt with presence in writing by reference to the Towney Mill and the Edmondson case at paragraph 33 of my written case, because this isn't a valuation case, but the established position is you ignore the presence of non-rateable plants for the purpose of valuing. You have to value vacant and to let, but by definition, this hereditament doesn't exist as a unit of property vacant and to let. Now, those are paradoxical effects, and I submit, and I've expanded on this in writing, that they flow from what I describe as a workaround of a self-contained code for plant and machinery, where this hereditament is existing only to identify that which is expressly excluded from being valued.
The concept of the definition of hereditament as a, quote, a unit of property, which we find now in section 115, or we find in the 1967 Act, section 115.
Yes.
When did that first come?
Section 68 of the 1925 Act, which is, that's what I briefly alluded to, paragraph 19 of my written...
Yes, probably.
Yeah.
And that's when it first came in.
Yes, and you'll find a discussion of that, the history of that in I think Lord Sumption's judgment in Walway. But the history of that was looked at quite carefully in terms of the actually, can I just check? So the terminology of unit of property came in 67, but you'll recall 67 is a consolidatory provision, and the may become dates back to the 1925 Act. So I think, to be fair, the unit of property flows from 67. The point.
Sorry, hang on. If it's a consolidated act, how do they bring in a new concept?
67 was yes. Well, they were effectively consolidating the 1925 Act, and they used that expression to confirm what the law, what the
case law was. I mean, I don't want to spend time on this, but is this explained by Lord Sumption? Or?
It certainly featured very heavily in the argument in Walway.
I'll leave it now. I mean, I can look it up.
The whole history of this featured very heavily.
You seem to be focusing on this expression, unit of property. And
yes.
I just wondered where it came
from. Can I just give the references for how the Scottish cases deal with this? So in the Lands Tribunal in Clydesdale, paragraphs 80, pages 18 and 19, Lord McGee, I think it's a passage that you've probably been shown already, says there's no questions of the subjects having any identifiable characteristics prior to the installation of the machine. And at page 20, he observed that the subjects would simply disappear if the machine was removed or indeed moved. So he's of a piece with leaving it out. And in Selector, which is an interesting case because it's vending machines in railway stations in Scotland, but at paragraphs 23 to 32, there's quite a focused discussion on the nature of the rights and on their heritable status, which is obviously looking at, is there property that can be entered in the roll, not taking account of the machine itself. So just drawing those threads together, it's absolutely clear that the upper tribunal took account of the machine. I say that's not the correct approach. I rely on Kennett and Wilkins. I also rely on the characteristics of the agreement in my case. So they don't specify a location for the machine, so we're not in Austin Reed territory. They don't specify the type of ATM, either the precise model or even whether it's a internal or external ATM on the face of the agreement. And I say that if you leave out of account the ATM, there's absolutely no segregation in any way of the floor space from the rest of the shop. The mere existence of the hole in the wall doesn't define the scale and boundaries of the hereditament, and the upper tribunal expressly accepted that, which is why they were driven to take account of the ATM itself. And I do rely, as directly applicable, the analysis of Lord McGee, that physically and functionally this is part of the shop, and the status of the sites are, as part of the shop, is their character, their predominant characteristic, I say both physically and functionally. And the true nature of the rights are the supply of services at our shop rather than the renting of space. And that's an expression I take specifically from Selector at paragraph 34. So where does this point go? Well, I say there's actually a straightforward error in the reliance on the machine to identify the putative hereditament. But even if you're not with me on that, it's clear from Clydesdale that the physical nature and relationships of use are critical considerations to the approach in a carving out situation, and these ought to be very weighty considerations in the type of multi-factional approach that is necessary. So that's my discrete point. May I then just deal very briefly with rateable occupation in terms of the Cardtronics position. So, as I say, I've adopted the legal analysis that my learned friends have set out. I say that a proper examination of the nature of the rights is a critical starting point in context. So, the rights, the physical context, and the functional context. In substance, unlike Westminster, which, as Mr. Mould showed you, was the letting out of unused space in exchange for rent, that's absolutely not apt in the case of my case. There's very little space, and there's a very close connection between the placement of the machine and the availability of cash, which is closely referenced in the agreed statement of facts and is on all fours with the analysis of convenience stores in the Clydesdale case itself. So there's a very clear purpose. There's no physical separation. May I just, on the facts, just put down a marker? My learned friend invited reference to a passage from the Valuation Tribunal's decision. This is in his note, by reference to MS 352-4. Now, there's a big health warning that comes with that, because the Valuation Tribunal is not the tribunal of fact. The upper tribunal is the tribunal of fact. That reference is a reference to the characterisation of the relevant factors advanced on behalf of the valuation officer. I don't accept that they are an accurate characterisation of the relevant facts in my case. For that, I would refer to my submissions to the upper tribunal, which are recorded at paragraph 158, as to how what became the express, which led to the express findings that in all cases there'd been no parting of possession, that the store in every case was in actual occupation, and that there was a common purpose. So those were the submissions that led to those conclusions from the upper tribunal. And also, may I call attention to the fact that part of those submissions was in our case where the contract is necessarily quite simplistic and the Cardtronics are actually providing the ATM. There was evidence that was recorded about, well, in practical operation, the contract isn't necessarily the be-all and end-all because there is a requirement of ongoing cooperation to make the servicing work, to maintain the electricity supply, matters of that nature, and also that there was evidence from the host store owner, Mr. Sodar, about the critical importance of cash in his store, and that is in the Supreme Court's bundle. The references are MS 953 to 955, paragraphs 9 and 11, and also the fact that that statement was expressly agreed in the upper tribunal. See MS 960, para 18, from the agreed statement of facts to the upper tribunal.
And that was a statement that...
So the bit that I rely on deals with the importance of the store, of cash to the store, and of the immediate impact on the manner and extent of expenditure in the store, where if the ATM's out of service in particular. So when the ATM's out of service for any reason, we instantly see a significant drop in overall cash payments, and then also of the benefit of effectively having a ready supply of cash is set out there. So that's from paragraph 11. And then also in the agreed statement of facts to the upper tribunal, there's reference to the fact that there's a very high level of cash expenditure, as one would expect, in a convenience store. So now, the only additional matter, so I say that the general control analysis that my learned friends have developed is entirely apt to the particular circumstances of Cardtronics. The only other matter that may be worth making short observations about is a matter that my Lord Kitchen has raised about the relevant interplay of questions of control and purpose, both of which are relevant from Lord Russell's analysis in Southern Railway, properly understood. And I do suggest that there is a correct foundation to the insight from Lord McGee that one needs to be wary about an overemphasis of control in a common purpose situation, because you are bringing about the very benefit which the store owner wants to achieve. So one way of achieving that is to allow another party to do that, because that is the method by which you choose to achieve your purpose. And that's within the concept that Mr. Mould has identified of the particular purpose of the retail occupier. So it is part of the particular purpose of the convenience store operator to achieve a ready supply of cash. That is achieved through not parting with possession, but allowing an ATM to be placed on his store for his purposes, to achieve his purposes. And it then makes little sense in that context, which is starkly different from Southern Railway, to focus unduly on questions of control in isolation from the other factors in the contextual analysis. And one authority that may assist on that is the Esso case in the Lands Tribunal, which is we've referenced that in our written case at paragraph 51 and then again at 57. And the point that emerges from that is that the absence of intervention is not inconsistent with the exercise of control, because actually allowing somebody competent to carry something out that achieves your purpose is the method by which you achieve your purpose, and that is not inconsistent with being in overall control. So our store owner doesn't have complex contractual rights that are equivalent to the supermarket situation, but there is very broad correlation of purpose. I would respectfully suggest a very strong correlation of purpose in the convenience store context, coupled with the de facto ability to control, but the common purpose that is there is the critical consideration, coupled with obviously the physical considerations and the use considerations that I've identified already. So I say that what the Court of Appeal did by putting this together under the rubric of general control was a sensible application, entirely consistent with what the Scottish cases have done, and that we sit very much on all fours with Clydesdale, and we are starkly different from the position in Bank of Ireland, where there is a separate ATM because there is independent, uncontrolled occupation and a sufficient disconnect between uses and purposes. Here there isn't a disconnect, there is a very strong unity of purpose, which is reflected in the upper tribunal's findings of a common purpose, which Lord Justice Lindblom carefully references in his conclusions on general control. And may I just, in the last few minutes, deal with a marker that there is a particular problem. This is in my written case at paragraph 82. There is a particular problem with the upper tribunal's reasoning in our case, because they effectively rely on what's their characterisation of rivalry in relation to areas that aren't anything to do with the ATM. And what I say that should have shown them is that the separation of items of property, taking the interdependency of issues into account, was the opposite of what the facts suggested. But in reaching their conclusion, should a different approach be made to small convenience stores, they effectively, having rejected the concept of rivalry, then brought it back into play and did it in a way that simply doesn't stand up. And I make those points in paragraph 82. They're only relevant because, as I understood it, from his written case, Mr. Morshead says this court should reinstate those conclusions, but actually in his note he expressly said he doesn't rely on them. So there's a particular wrinkle in the upper tribunal's logic in our case. I'm conscious that, I'm probably less than...
Said looking impatient.
Yeah, he is. I mean, I've had slightly less than my allotted time, but I'm not sure the court needs to hear my conclusion, drawing the threads together, if you understand the thrust of my submissions and also the way in which I fit my particular facts into the legal arguments which have been developed by others.
Yes, we also have the benefit of a very full written case.
Yes.
Can I just 2 points? One, it would help me to have a note at some point on the background of the expression unit of occupation as it appears in the 1967 Act. If you say it's a consolidation, where does it come from? And the other is if the note could also remind me of the jurisdiction of the upper tribunal in relation to the valuation tribunal, which I ought to remember, but I don't. So you're going to see exactly who is the fact-finding tribunal and where it comes from. But just to see chapter and verse. Thank you.
And Mr. Wilcox, do you follow?
Mullen.
Mr. Morshead.
Awesome lady. Perhaps detect how at all stages throughout these proceedings I end up feeling a bit like a minnow circled by a great many very powerful sharks. And it's a serious point. It is a serious point. It imposes an extra heavy burden on the members of this court to scrutinise the arguments that have been heard by these respondents. Obviously, I cannot take all the points that have been made in detail in reply.
You really needn't be concerned about this.
And
it's a familiar problem, particularly in public law cases.
I'm grateful for the reassurance, but in order to anticipate the risk that there will be many things I don't cover, we've prepared a short note that just deals at an overview point with the main points. I'm not going to read it out because I'd like to respond dynamically to the points as they've arisen, if I may, but can it be distributed now so that it is at least as a document that's been handed in during the hearing? I think the best way for me to attempt to deal with all of this is to start, if I may, with the Holkin case, which was the foundation of Mr. Drabble's argument on behalf of Sainsbury's, and the foundation of the generic response made by the respondents on the main point in this case. And as my Lady Black has pointed out, the Holkin approach, no more than the Southern Railway approach in my submission, is one which presents a test that is capable of being addressed in a very straightforward fashion. I just want to remind the Court of the very passage that Mr. Drabble quoted at page 1125 from the speech of Lord Herschel. What was decisive in the opinion of the Lord Chancellor was that the respondents alone have the right of using the tunnels. That's not a question about purpose. Then Mr. Mould deftly said, well, when you look at the way Lord Russell puts it in Southern Railway, he introduces the use of the word purpose. Well, he does use the word purpose, but what does he use it to do? He uses it to direct the court to an examination of what is achieved by the agreement in question, not why was the agreement entered into. And the same is true when we look at Lord Wright's speech, and the same is true when we look at Lord Justice Tucker's speech in Lang. I'd like to show you the relevant bits of that at page 1147. Just above, halfway down the page, there's a sentence beginning the measure of control. Sorry, just above that, I think it has been rightly stressed that what one has to determine is the quality of the occupation of the premises. The measure of control by the ministry in carrying out the contract is a different thing from a control interfering with the exclusive occupation of the hereditament. I read those words again. The measure of control by the ministry in carrying out the contract. All we have seen in this case are measures in the hands of the stores to varying degrees about the way in which the bank must carry out its contract. And they are distinguished explicitly by Lord Justice Tucker from a control interfering with the exclusive occupation of the hereditament. What does he mean by exclusive occupation of the hereditament? He means exclusive for the purposes for which there was an occupation. In our case, operation of an ATM site. You see that from the way he approaches the question. He's not asking why did the transaction take place. He's asking all the time, what did the transaction do? On reading the conditions in this contract and comparing it with the Southern Railway case and the principles there enunciated, the conclusion I've arrived at is that the ministry is not in this case such control as to render the occupation of the contractors an occupation which is not rateable. In other words, I think the real control exercised by the ministry was a control with regard to the performance of the contract. All this, that's a keep open clause. You have to generate, the bank has to generate a number of transactions each month. All that kind of restriction falls into that category. How must the bank perform its contract? Not a control which interfered with the exclusive occupation of these hereditaments for the purposes of their work by the contractors. And again, reference was made to this idea of a test of general control, which is another expression that Lord Russell used. General control is not another gateway into this question. It's not an alternative form of analysis you can adopt depending on how you categorize the cases. General control is the process described by Lord Russell. Similarly, the lodger principle is explained by Lord Russell as being a function of the general control test. Lords, if I may make this brief submission, in light of the arguments that the court has now heard, I suggest it is possible to restate the lodger principle in the way I indicated in my submissions, to which there's actually been no answer. And it might be a helpful way of thinking about it, so I'm going to read it again. It's that the distinctive feature...
Can we go to that passage?
I did in Lord Russell's speech, but I saw...
What you said is in your case.
Did I? I meant when I was speaking.
Oral
to the
submissions.
court, my
Oh,
oral
I see. Sorry,
submissions.
no, I thought if it was neatly encompassed, I'd love to see it.
I'm happy to write it down, but it's actually quite a simple point to make. The distinctive feature of a lodger case is that the lodger is present in the hotel in order to receive a service provided throughout the hotel by the hotelier. By contrast, the presence of an ATM site in our cases is not referable to the bank being on the store to receive any retail service by the store. That is the point of distinction.
Does it not receive a service in the sense that it is located in an area where people, to which people regularly have resort, and therefore may well be attractive?
That's exactly it, my lord. That is exactly it, because that is the point which makes it impossible to distinguish a bank's ATM site from a prime site in a shopping centre, a prime site somewhere else. Of course, every landlord is going to want to attract occupiers, of course. And of course, every occupier is going to want to situate its business in the most attractive point. But my lord, your lordship is exactly right.
But I mean, that's why Smiths want to have a shop in the
Exactly.
in the railway station.
Exactly. That's exactly it. That cannot be a sustainable basis for applying the control principle or the lodger principle. It's a snake that swallows its tail. Now, Mr. Mould and Mr. Drabble and Mr. Kalinsky were forced to recognise that their approach necessarily means that the court has to engage in a multifactorial, meaning discretionary approach. That's what it means. That only arises because they are asking in substance, they've carefully avoided the words, in substance they are asking, why did the transaction take place? As soon as you open the door to that why question, you can't avoid that sort of incommensurate issue, as it was called in Mazars, cropping up, an antithesis of the sort of question which it is appropriate to pose in a field of taxation, where precision, predictability and certainty are paramount considerations, as well as fairness between taxpayers. The question is not why did the host appropriate a small unit to the occupation of a third party. The host's reasons may have been good, bad or indifferent. Usually the host will have a good reason. In fact, can you think of a situation where the host would admit a business rival, someone whose occupation did not advance his own business? The question is simply this: has the host appropriated land to the use by a third party for the provision of ATM services? That's the whole problem in a nutshell. We pointed this out in our case, and we haven't been shown to be wrong. We've done it by reference to Wimborne, which you haven't actually been shown, but it might just be worth reminding the court of what was said in Wimborne, because it meets one of the questions my Lord Reed had about the difficulty of reconciling the concept of paramount occupation with exclusive occupation. Wimborne is at page 1353. Sorry, it starts at memory stick 1344. I've given a wrong reference. The bit I wanted to go to was at 1349, first of all. I'm just doing this very briefly. I appreciate your lordships and my lady will wish to come back to this case. This is the first time it's been looked at. But 1349, in the judgment here of Lord Justice Lloyd. Moreover, he says and this is in the context of considering this test, the top of page 1349, moreover, one has to be wary in this context, as in almost every other context, of the word purpose. Here the Crown Court was using it in what I believe to be the correct sense, namely the object of the activity in question rather than the motive behind the activity. Counsel for the rating authority put it epigrammatically when he said that purpose in this context means what a man does rather than why he does it. And the court, with reasoning, ultimately comes to that conclusion and approves what was said by the Counsel for the Rating Authority. One other passage which meets the concern my Lord Reid had about how do you reconcile this idea that you can have an exclusive occupation and at the same time be thinking about paramount occupations. That's grappled with at page 1353. The paragraph that begins, but in that case, you have that, it will be remembered the licence didn't even purport to be exclusive. I find some difficulty during the argument in understanding how the requirement that occupation must be exclusive could be reconciled with a well-established rule that where there are two competing occupiers of the same hereditament, it's the paramount occupier who is rateable. If there are two occupiers of the same hereditament, how can either be exclusive? And I think that was my Lord's question.
It
basically.
was.
Yes. Counsel for the ratepayers submitted in the reservoir aggregates case that the paramount occupier is treated as being the exclusive occupier. Another way of explaining the difficulty might be that an occupier, in order to qualify for rateable occupation, has only to be in exclusive occupation for his own particular purposes. And if the court has the opportunity to revisit Vitesse, I might show it some passages of that if I have time this afternoon, you'll find that that is how the then President George Bartlett approached the question when deciding whether these tiny optical fibres could be in the rateable occupation of Vitesse, even though all Vitesse did in order for that to be in rateable occupation was shine light through them.
But I mean, that passage seems to be very helpful in the sense that it sort of reconciles what seemed to be irreconcilable.
It helps because
is it orthodox?
Yes, it is. I mean, one of the problems in any case like this is translating concepts into language. A case like this brings us to the edge of what language can deal with if you're going to drill down into it philosophically. That's why Lord Russell's approach is so helpful.
Well, what Lord Justice Lloyd says in the passage you just read is actually very similar to what was said by Mr. Justice Jenkin in the Tucker case.
I don't have it.
No.
Is it Lang?
Lang.
Lang.
Yes.
Can I just reduce it to the very basic, which we can put into language? You start with the store, which is in possession of this piece of space and is ceding it to greater or lesser extent. It wants to do it. It's using its space, just for the purposes of this hypothesis, to provide the service of the ATM. Why is that any different from stacking the pile of lager, which we saw in one of the photos?
Yes, this is the. I was going to come on to that because I appreciate that, from the perspective of the shopper, there's no difference. From the perspective of the shopkeeper, it's no different. From the perspective of the casual observer, it's no different. Is that the right perspective? If you have to examine the rights and obligations of the parties in relation to each parcel of land, in order to make sure that nobody is wrongly escaping rating, then you appreciate that rating has to look at things from a different perspective. Rating is not blinded by the fact that it all looks like an indistinguishable function, one single indistinguishable function. Rating has to look at each unit of land and see what are the rights and obligations in respect of that unit of land. And my lady, it's the point made in Old Consort. The shop didn't have to provide this cash service by letting a third party in on an appropriated piece of land.
It didn't have to sell lager.
When it sells lager, it's selling its lager. May I come back to this point, I think, because I've got limited time and I don't want to be deflected from the flow because I think I'm going to be covering it. The Court of Appeal has outwardly acknowledged that the motive of the parties is irrelevant. But the effect of examining the degree to which an occupier of the smallest unit is operating a business which complements the host is always going to introduce the why question. Always. And I say that occupation of a unit of land is never made less exclusive merely because the use of that unit brings advantages to another unit. And this is one way of answering my lady's question. Mr. Drabble said Sainsbury's gets a direct benefit from what he calls its occupation of the ATM site. And I think that's my lady's point. That's one way of looking at my lady's point. Let's unpick that. The actual right granted, says Mr. Drabble, was just a right to install this machine. That's not right. I showed you the agreement. It's a right to operate the machine. It's the bank that operates the machine. That's the first point. Second point, look at the ATM machine. You can do it literally. We can open a photograph if that would help. But we can imagine in our minds the box and the robot inside it. There's been no challenge to my analysis of that box as containing a robot, which is a virtual employee, who is the bank's employee. There's been no answer to that point. But look at it just physically. Sainsbury's does not occupy that box in any way. That is a volume of space from which Sainsbury is completely excluded. It's smaller than a shop, but so what? Does it occupy it by its chattels? No. All the cash in that box belongs to the bank. All the stationery in that box belongs to the bank. The robot itself belongs to the bank. So, if you're looking for indicia of occupation, zero. Literally zero. But what about use? Because after all, occupation can be manifested by use. So does Sainsbury's use it? Well, its staff replenish it, and they provide frontline services. But is that a use of the ATM? Is that a use for the purposes of operating an ATM? If so, is my landlord using my flat when he enters to repair the roof? And does it matter that he lives in the downstairs flat so that the roof and keeping it in good order keeps both of us dry? He gets a direct benefit, but surely nobody would suggest that the landlord, even if under a right enters my land to repair the roof, is using my flat in any way that could be relevant. He's just relevantly a contractor. So the staff's operation are not a use, and by the way, it's only in connection with Sainsbury's that we even reach that question. So, what's left? No occupation, no use. What about control? Well, what are the controls? There's been no analysis of the contracts to show any control which interferes with the use by the bank of the ATM site for the purposes of providing ATM services. And indeed, none in the upper tribunal, or in the Court of Appeal, or in the Respondents' printed cases. The whole argument before oral argument today proceeded on the basis that there was no distinction between the contracts in Southern Railway and these cases. Only today, for the first time, has there been an improvised attempt to introduce distinctions. That's problematic for this court in my submission. I say you should not decide this appeal in favour of the respondents on the basis that there are contractual differences between Southern Railway and our case. But if you do go down a route of comparing the contracts, I respectfully remind the court of the need to be cautious about accepting that any difference you find has any legal consequence. The emphasis of the respondents' arguments has been repeatedly on the idea that the ATM is providing a service which the store finds important or essential to its retail offer. And this is another way of dealing with my lady's question. The store did not have to appropriate land to the occupation of a third party. It could have provided a cashback service at its own cash registers, using its own cash, or simply incurred the expense of obtaining regulatory approval to run its own ATM machine plugged into the bank's network. This is the point made in Old Consort. There was the method by which you do a thing makes a difference in rating. It's explicitly a point made in Old Consort. It may have legal consequences that the store has chosen to fulfill this retail objective in a particular way. And the method it's chosen is indistinguishable from Southern Railway and Old Consort. Lords and my lady, I wanted to spend a few moments at this juncture asking a question which actually we haven't considered yet. What is the problem created by our approach that the respondents' arguments and the Court of Appeal's approach is addressing? What problem is created? There's no problem from an administration point of view. There's no limit on the amount of ink in the valuation officer's pen when it comes to writing the list. He doesn't care how many entries there are in the list. What's the problem for the shop? It makes no difference to the operation of the shop whether there's one hereditament in the list or two. There's no case in which the rates paid by the shop have gone up just because someone else also has to pay rates. In fact, in at least one of the cases, the shop's rates have come down. So what's the problem? The only person with a problem, it's the bank. And what's the position of the bank? Why doesn't the bank like it? Well, suddenly, rating has caught up with this new way it's adopted of doing business.
Well, I suspect the problem for the shop is that it's not going to be a very attractive location for the bank to locate its ATM. That hasn't been articulated, but seems to me to be a fairly obvious problem.
They have to pay rates like everybody else.
Oh, quite. But
my lord,
if someone who's going to install an ATM in their premises is going to have to pay rates, that makes it a less attractive proposition.
They pay rates everywhere else they put in ATMs. They pay rates when they put an ATM into the outside of an office building or in a railway station. Why not a retail shop or an airport? What is it about this activity of retail that gives it a special privileged position in rating, where anyone the retailer lets onto its shop is immune from the normal consequences of land being appropriated to its use? It's an unsustainable position, and this is really why we're here, my lords and my lady. When I say unsustainable, I mean it literally. If this problem isn't made to go away, it's going to be a big one in the law of rating. It won't be the last you hear of it. If we think it's a counter...
Promise or a threat?
if we think it's counterintuitive to treat an ATM in a store as a separate unit of assessment, we likewise need to unpick whether our first impressions are sustainable. I've accepted that to a casual observer, an ATM, the wall of a store, or inside the store might look just like part of the site. If it's inside the store, when you take cash out of the machine, you might not think you're doing anything much different from taking a cabbage from the shelf next to it. Of course I recognise that. The same may be true to the shopkeeper or the managers or the staff themselves. But likewise, to a casual observer, or even to an engineer, the bundle of fibres inside each core in V-test would have appeared as an indistinguishable mass. You'll remember that in V-test there's a bundle of optical fibres, tiny, hair thickness things, wrapped together in a bundle about the thickness of your finger, or maybe the thickness of your fist, I can't remember what. There can be dozens or hundreds of them in a single tube.
That doesn't really help us, does it? I mean,
Well,
the trouble is, at this stage, after 2 days of this, one begins to glaze over.
I know. And I'm trying to bring it back to life. But
I mean, you are going to leave yourself time to deal with Mr. Kalinski's separate point, are you?
I will try. Well, I'm going to try to.
I don't want to talk, but the trouble is, I think we go around these cases, and it's not easy to really piece them together. We're going to have to go away, as you said, read them all and try and do that. So,
All right. Well,
and I don't, my colleagues.
there are very substantial practical problems which arise on the Court of Appeal's approach. How are you going to tell at what point the tipping point comes? And it's really an unjusticiable problem.
I think the striking point you made, which is very important, is how many variables there are. I mean, you talk about that. I mean, you've got so many different situations to which one has to try and apply these rather words in the statute. But I think we've got that.
Well, I better move on as fast as I can then. I'm just emphasising that these problems don't arise on what I say is what the tribunal called a conventional application of Southern Railway. Briefly then, Mr. Mould's submissions on Wilkins. He asked, is there a chattel enjoyed with land which, if it exists, has been occupied long enough to be a hereditament? In our case, I say the answer is yes. The site of the ATM includes the volume of the chattel situated on it. I'm not sure, I still am not sure I've really understood the meat of the point being made against us. I may have detected the argument to be a really technical one about what are the words we've used to describe the ATM site in the list. At one point, it sounded as if it was about how do you interpret an entry in the list which refers to ATM site. And he seemed to be saying, well, the valuation officer says it's just the flat bit of ground on which the ATM site is situated. Well, that's a question of interpretation. It might be the flat bit of ground, or it might include the volume of space occupied by the cash machine, or the volume of space with the cash machine in it. I don't see how resolving that question is going to affect any of the points of substance before the court. It's hardly a helpful point to be addressing at this level, I would have thought. I got a hint of that suggestion in learned friend Mr. Kalinski's arguments as well. It seemed to be that if only we'd used different words in the list, we might have had a different effect. I'm not sure how that's helpful in dealing with any of the points of substance that arises, frankly. On the plant and machinery point, again, I'm not sure I must be missing something. The kiosks in Southern Railway are non-rateable plant and machinery. They're rateable. I'm genuinely not sure what point I'm missing here. The huts in Wilkins, non-rateable plant and machinery. What's the point that's being made? Unless it is this narrow point that we've somehow used the wrong words in the list to describe the site.
What Kennett, you seem to say in your case at page 20 is authority for the contrary proposition.
Well, yes, if we look at...
I mean, what Kennett said, which I certainly hadn't picked up before, was you ignore the plant and machinery for all rating purposes. Now, I mean, this point wasn't taken in either any of the other cases. It wasn't taken in Southern Railway. I'm not sure it existed as a point at that time.
Just if we can remind ourselves, please, page 1152, back in Kennet. The context in which we find the words on which Mr. Kalinsky founds this argument appears about halfway down with the sentence, "So it was rightly conceded." This is a point that went by concession.
Yes, all right, but it was conceded by a very experienced counsel and accepted as correct by the House of Lords.
My Lord, all that is established by this part of the reasoning of nothing that's established in this part of the reasoning bears on the issue which now arises. And if you look at what Lord Keith himself did with the presence of chattels, he did use it in order for a rating purpose at the foot of page 1152. This is in substance a finding that the business purpose to serve which the respondents brought hereditance into existence was the housing of telephone equipment. If that be correct, there can be no doubt that the respondents were enjoying the accommodation which the hereditaments afforded from the moment that some equipment had been moved in. So the presence of non-rateable plant and machinery is being used by Lord Keith himself for a rating purpose in the very paragraph after he has said you can't use it for any purpose. It's clear. What
What are you saying, Lord? I'm trying to understand. Mr. Kalinsky's tried this argument out 3 levels without success, but I respect him sufficient to know that he wouldn't be banging away here, use that expression again, unless he thought there was something in it.
Well, I don't know. It's been explained by the upper tribunal and by the Court of Appeal. The upper tribunal at 122 to 126, and the Court of Appeal at paragraphs 45 to 50. Ultimately, it comes down to the question of statutory interpretation which arises. Is it legitimate to interpret the plant and machinery regulations in a way which means that as well as obliging you to disregard plant and machinery for valuation purposes, you are obliged to disregard it for other purposes also? There was no power to make a regulation having that effect. There is no power to do it. Mr. Kalinsky persists with this point because he's got a special interest in doing it. He alone, among the respondents, is the party whose arguments can't survive the Bank of Ireland case. The Bank of Ireland analysis, where you've got an external ATM with no one servicing it, you've got a problem. That's why Mr. Kalinsky needs to go.
I assume he also thinks it's a good point, although he would.
Well,
there we are.
My Lord, it would be ironic if, having got this far, it turns out to be that there's a simple answer all along, based on the plant and machinery regulations, which are about valuation.
Wouldn't be the first case which that happened.
It wouldn't be the first, and I hope no one's going to rise to that challenge, because it really isn't an appropriate way of.
Anyway, so I just wanted to make sure you dealt with it, but I'm not expressing any view on it at all at this stage.
The ratio of this case is that there was a rateable occupation. That is the ratio of Lord Keith's speech in Kennet District Council. What he said about the need to disregard plant and machinery for all rating purposes is obiter to his reasoning and to the conclusion in the case, and as it went by concession, it is not a matter to which this court ought to attach any weight, especially as the same judge in the same judgment uses non-rateable plant and machinery for a rating purpose. So far as concerns ESSO, the critical point about ESSO is that when your lordships and my lady examine that case, you'll find that ESSO, which owned the site of the petrol forecourt filling station and allowed Road Chef to operate it, allowed Road Chef's staff in under an agency agreement, explicitly. Road Chef's staff were ESSO's agents. That's the relationship which is excluded by all the contracts that we've seen in our case. So ESSO isn't going to help any of the respondents. There is quite a lot more that I could and would love to say, but I appreciate
We got your
you've
helpful
got.
note.
I'm not sure how helpful you'll find it, but I hope as a sort of emergency reserve, there it is.
Read.
My lords, before I sit down, I hope I'll be allowed to assume that it's not too presumptuous, the function on behalf of all those addressing the court, and perhaps on behalf of the bar, of thanking Lord Carnwath for his services in this court with the warmest possible respect and best wishes for a happy return.
Thank you very much indeed.
Thank you very much indeed, Mr. Morshead. Well, we're most grateful to all counsel for their submissions. This is obviously a intellectually intriguing and important case, and we'll now take time to consider our decision. The court will adjourn.